These three are covered. This one I have to check. I got feel free to go somewhere else, right?
Hey, Sammer. Morning.
Good morning.
Are things a little bit better now?
Working on it.
Oh, I'm sorry.
Yeah. Yes, two, right? Yes. Yep. Court Town Session, the Honorable Lisa Martin presiding.
You may be seated. Michelle, giving me her countdown. This is 23HR 13898. This is Huron Township versus Gary Burka.
Good morning, Your Honor. Alex Giuliani, P81837, appearing on behalf of Gary Burka, who stands to my right.
Good morning. State your name for me, please, sir.
Gary Burka, Your Honor.
Thank you, Mr. Burka. Today is the day and time scheduled for sentencing in this matter. There was a date of offense of December 13, 2023, at which time Mr. Burka was charged with operating while intoxicated. He appeared before this court on February 20th, 2024, and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy with drinking and driving offenses, he was referred to the court's probation department for the development of a sentence recommendation. The court is in receipt of that. I have reviewed the report from probation officer Anthony Grant in its entirety, along with your intake sheet, your needs assessment, the police report, your criminal history, and the supplemental police report. Have you had the opportunity to review this information with your client?
We have, Your Honor, we did go over it together. It is factually correct. No additions, corrections, or deletions. At this time, I do just have a brief allocation.
Please proceed.
Thank you, Your Honor. Your Honor, Mr. Burka is 46 years old. He has no prior criminal history. He is very educated. He has, he's employed, has his own businesses, very successful. This is out of character for him. He has learned tremendously through this whole experience. He took proactive measures on his own, got enrolled in Henry Ford Intensive Outpatient Program. He completed that program. He sat on the Victim Impact Panel. He learned tremendously through that, as well as AA meetings. So, Your Honor, I'm asking for you to go along with the probation department's recommendation at this time. I believe since, you know, Mr. Burka's done so much proactively since this offense happened, and I believe he's learned, and he will never do this again. Thank you.
Thank you. Sir, was there something you wanted to say on your own behalf?
No, Your Honor, I just wanted to, reflect on what my attorney stated. I have learned quite a bit through the program. I've been exposed to a lot of things that I had not previously been exposed to through the ILP program and through some of those AA meetings. And let me just say it was very eye-opening. The entire process has been eye-opening. And I hope that I can, be a person in society that can help others to avoid the mistakes that I made. I feel very regretful for my decisions and look forward to moving forward without making such grievant decisions in the future.
Thank you, sir. Mr. Grant, was there anything you wanted to add?
No, Your Honor.
Thank you. Again, the court has had the opportunity to review the file in its entirety. And Mr. Burka, your summary of the MAD panel that you sat on was quite insightful. And based on the steps you've taken in response to the events that happened on the night in question, the court will adopt the recommendation of Anthony Grant, the probation officer, and impose fines and costs. Will not place you on probation in this case. There will be a fine of $300, cost of $100. There is $241 restitution due to Huron Township. There's $75 mandatory crime victim fee, $50 mandatory state fee, $20 fund fee. Court will order that you complete 24 hours of community service within the next 90 days. If you don't already have a nonprofit organization that you're affiliated with where you can get those hours done, reach out to Mr. Grant. The probation department maintains files of organizations that could use the help and assistance. You will need to provide documentation of those completed hours with Mr. Grant. You will need to also make regular monthly payments on the fines and costs and restitution. This matter is a total of $786. If you're able to pay that immediately, great. Otherwise, you'll need to be in contact with the court's collection department to make a payment plan, okay?
Thank you, Your Honor.
Is there anything else, ma'am?
No, Your Honor, thank you.
Anything else, Mr. Burka?
No, Your Honor.
That concludes this matter. Good luck to you, sir. You have a wonderful afternoon, okay?
Thank you so much. I appreciate it.
Thank you.
Thank you, Your Honor.
Mr. Jadala, have you had the opportunity to speak to your clients this morning?
I've talked to both Mr. Bennett and Ms. Yarborough, Mr. Yarborough, Judge, and good morning.
Thank you. This is 23 HR 13641 OD. This is Huron Township versus Travis Bennett.
Your Honor, respectfully, Sam Jadala, P62186, appearing on behalf of Mr. Bennett, who is currently approaching the podium, Your Honor. Your Honor, I've had the opportunity to speak with Mr. Bennett and I've gone over his pre-sentence report. There are no errors, omissions, corrections, or deletions. He understands the recommendations made by this court, and he fully intends on, Your Honor, he fully intends on following those recommendations. I've also advised him, Your Honor, to provide probation with a full list of his current medications, so there can be no dispute about what he's currently prescribed by a doctor that he's currently seeing, Your Honor. He does understand, and he's going to fully do that with probation after today's sentencing.
Thank you. Would you state your name for me, please, sir?
Travis Lee Bennett.
Thank you, Mr. Bennett. Today is the day and time set for sentencing in this matter. There was an offense dated December 28, 2023 in Huron Township, at which time Mr. Bennett was charged with operating while intoxicated. He appeared before this court on February 20th, 2024, and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy with drinking and driving offenses, Mr. Bennett was referred to the court's probation department for an interview and development of a sentence recommendation that was done by probation officer Anthony Grant. The court has had the opportunity to review the interview summary in its entirety, along with the probation intake sheet, Mr. Bennett's needs assessments, his criminal history, his driving record, and a police report from the night of the night of the incident. And Mr. Janali, you've indicated that you've had the opportunity to review that same
That is correct,
information with Mr. Bennett,
That's correct, Your Honor.
and it's factually accurate.
Actually accurate, yes, Judge.
Any additions, corrections, or deletions?
None, Your Honor.
Is there anything you'd like to say on behalf of Mr. Bennett?
Just that, Your Honor, I've gone over this. My client is very remorseful. He understands the mistakes that he made, and he fully intends not to repeat them, Your Honor. He is under treatment from various doctors, Your Honor, and that's why I've advised him to make sure that he brings in all documentation to probation, so they understand the various medications that he's taking, because he does understand he will be testing as a requirement of probation.
Thank you. Mr. Bennett, is there anything you'd like to say on your own behalf, sir?
I was just clarifying that the accident happened on August 22nd of 2023 and not the date stated before.
Thank you. And Mr. Bennett, you corrected me the last time, and when I made notes reviewing the file, I put it on my sheet that was August the 22nd. I'm not sure why it still is showing as December 28th.
Yeah, after the accident, I was at the ambulance picked me up, so I just have the medical records for that from that point. So that's how I remember the date.
Mr. Bennett, and I'm smiling because when you were here on February 20th, we went over the same information and the correct date is written in the file. It's just still wrong on the file. But is there anything else you wanted to say, sir?
I think the police officers and the EMS team that they basically saved my life in the situation, and I have remorse for my decision and will never do that again.
It's been 8 months since the accident. How are things now with you?
I've been struggling, and I'm seeking help. I've had insurance changes. Just recently going from state to private insurance through my employer that I've been with for a year.
Okay.
So it's just been difficult finding new and different, support that I've already had, rapport with. So in that sense, I will be actively seeking within the next 30 days to be in an outpatient program.
Mr. Bennett, again, the court did review the notes that Mr. Grant provided from his interview with you, and the court will adopt the recommendations that he's made. The court will place you on 12 months of probation. You will be responsible for the oversight fees associated with that probation. The court will impose a fine of $200. There's cost of $100. There's $75 mandatory crime victims fee, $50 mandatory state costs, $20 fund fee. There's $125 in restitution due to Huron Township. You will complete 24 hours of community service at a nonprofit organization and provide documentation to the probation department. If there's not an organization that you already have a relationship with, be in contact with Mr. Grant or the court's probation department. They will assist you in making that connection. You will enroll in substance abuse treatment within 30 days of today's date and follow all recommendations from that program, providing documentation to the probation department. You will not purchase, possess, consume any alcoholic beverages or non-prescription controlled or mood-altering substances without this court's approval. You will submit to random ETG testing a minimum of once per week or as otherwise directed by probation. You will make regular monthly payments for the fines, costs, and oversight fees that have been assessed in this matter, and that's something you can set up with the collections department. Mr. Grant will be in contact with you because there are documents that will need to be signed that will put you formally on probation. And what I would encourage you to do is if you find yourself struggling, needing assistance and accessing resources so you're successful on probation, reach out to Mr. Grant. You may call him, you may email him, you may come in person. He's here 4 days a week. I'm here 5 days a week.
Certainly.
The court's goal is not to see you again. The court's goal is to provide you support along the way so that when you're stumbling a little bit, you feel free to reach out and that you'll get some support, okay?
Certainly.
Is there anything else in this matter, Mr. Jadala?
Nothing further, Judge. Thank you.
Thank you. Anything else, Mr. Bennett?
No, thank you.
Good luck to you, sir. Have a good afternoon, okay?
You too. Goodbye now.
Thank you. What? This? You want this? Why do you want this? Of course it is. I appreciate you. Thank you, ma'am. 24 HR 0027, excuse me, 24 HR 00237B. This is Huron Township versus Austin Yarborough.
Respect to Your Honor, Sam Richard Dollar, P62186, appearing on behalf of Mr. Yarborough, is currently approaching. Your Honor, I've had the opportunity to speak with Mr. Yarborough regarding his pre-sentence report. There are no errors, omissions, corrections, or deletions. Your Honor, he does understand the recommendations. We just are going to wish to allocate briefly at the appropriate time.
Thank you. Would you state your name for me, please, sir?
Austin Yarborough.
Thank you, Mr. Yarborough. Today is the day and time scheduled for sentencing. The court has had the opportunity to review the information provided by Mr. Grant. There was an offense date in this case of January 6, 2024, at which time Mr. Yarborough was charged with operating while intoxicated. He appeared before this court on February 8, 2024, and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy with drinking and driving offenses, this matter was referred to the probation department for interview and development of the sentence recommendation. The court has reviewed that recommendation along with the intake sheet, the driving history, the criminal history, and the police report from the night in question. Mr. Janala having indicated that that information was factually accurate, the court will now hear the allocution in this matter.
Your Honor, I've had the opportunity to speak with Mr. Yarborough. He lets me know for the last month, Your Honor, he was in South Carolina, where he's originally from, where he has his child's mother and his 3-year-old child there, Your Honor, and a job opportunity. He did fly back. That'd be great. He did fly back, Your Honor, on Saturday, Your Honor, just for this sentencing here, Your Honor. He would like permission to have probation transferred to South Carolina so he could be with his family and take the employment that he's been offered.
I did not see that information in Mr. Grant's summary of the interview. Had you relay that information to Mr. Grant, Mr. Jadala?
Your Honor, I believe my client did relay that message to probation. He said it shouldn't be a problem, so that's why we just wanted to bring it up today.
Understood, thank you. Mr. Yarborough, is there anything you want to say on your own behalf?
That I'm sorry and that I'm learning from my mistakes, and I hope that nothing like this ever happens again.
Thank you, sir. The court will note that the report provided by Mr. Grant indicates that this is Mr. Yarborough's first alcohol-related offense. And based on that and the responsibility he took regarding his actions on the night in question, the court will adopt the recommendation made by Mr. Grant, place Mr. Yarborough on 12 months of probation with the associated oversight fees, and impose a fine of $200, cost of $100, their $75 mandatory crime victims fee, $50 mandatory state costs, $20 fund fee, and $206 in restitution to Huron Township. Additionally, Mr. Yarborough is to complete 24 hours of community service at a nonprofit agency. Sir, if you don't already have a relationship with a nonprofit that you can get your hours completed, I would usually suggest that you reach out to the probation department. But if you're going to South Carolina, you'll need to be more proactive in making sure those hours get done, documented, and turned into the court's probation department. You will enroll in substance abuse treatment within 30 days of today's date and follow any recommendations from that program and provide documentation to the probation department. You will not purchase, possess, consume any alcoholic beverages or non-prescription controlled or mood-altering substances without the court's approval. You will submit to random ETG testing a minimum of twice per month or as otherwise directed by probation. You will make regular monthly payments on the fines, costs, and oversight fees that have been assessed in this matter. That's a total of $1,131. You can set that payment plan with the court's collection department. Mr. Grant will be in contact and communication with you to formally place you on probation and assist you or support you in making sure that South Carolina is able to provide you the support you need to complete your term of probation. Because you are leaving, your reporting to him will be done by Zoom, so you will be responsible to make sure that you do and discharge all of your obligations to this court. Mr. Jadala, is there anything else this morning in this matter?
Nothing further, Judge, and thank you for your accommodations in this matter.
Absolutely. Mr. Yarborough, anything else, sir?
No, Your Honor, thank you.
Good luck to you. Thank you.
May you and your staff have a wonderful day, Judge.
You too. Good to see you, sir.
See you Wednesday.
Oh, here's Andy. Did the file come up? Andy will have to bring her file up. 3 people. Who's?
You'll like that there. You can do it as well.
Until
April the 6th.
April the
No,
6th,
sorry.
May the 6th. Oh.
Is it raining?
Yes. And I'm hoping that. She'll read the file.
I'm glad we talked and figured out this.
Morning, Mr. Evans, can you hear me? Sir? Mr. Evans? Sir, can you hear me now?
Yeah,
Hi, good morning. My senior attorney signing on, you were supposed to be here in person?
you said I was supposed to be there in person?
Yes.
Oh, she said it was a Zoom meeting.
No, but I see she's zooming on right now. Ms. Phelps?
Hello, good morning.
Hi, good morning. I'll let the judge know you're both on Zoom. It was a live hearing.
Oh, really? I thought we discussed it being on Zoom when we took the plea.
Oh,
I'm sorry.
okay. No, that's okay. I'll let the judge know you're here.
Okay, thanks.
You're welcome.
This coffee.
Good morning, Van Buren. I'm going to go ahead and put you into a breakout room. We're just waiting for Attorney Josh Kaplan to join us. As soon as he's here, I'll put him in with you so that Mr. Herring can speak with him prior to arraignment.
Okay, sounds good. I don't even know what to press. I don't even want to press it because of.
Good morning, Josh.
Good morning.
I've got Mr. Herring here in a breakout room. I'll go ahead and put you in with him.
Thank you.
Mhm. Josh, were we ready to go on the arraignment?
We are.
All right, I'll let the judge know. Thank you.
Thank you.
Mr. Kaplan, long time no see.
It is a pleasure to see you today. I wish I saw you more, for sure. I promise you, Your Honor, I'm not avoiding you.
240018, I'm sorry.
I said, I promise you, I'm not avoiding you. I promise.
This is 240018 FY State of Michigan versus Herring. May I have your appearances, please?
Joshua Kaplan on behalf of Mr. Herring. Mr. Herring, we state your name for the record.
Giannis Herring.
Thank you. Mr. Herring, you've had the opportunity to speak to Mr. Kaplan this morning. You understand why you're here?
Yes.
Thank you. Mr. Kaplan, how are we proceeding this morning with this arraignment?
For purposes of arraignment, we're going to waive formal reading, stand mute to the charges, Your Honor.
Mr. Herring, you were able to hear Mr. Kaplan just now?
Yes.
He's waived your right to have the court read the formal charges against you and has you stand mute to those charges. Sir, you also have a right to be represented by an attorney going forward in this felony matter. If you're unable to retain an attorney through your own resources, the court is able to appoint one for you. Attached to the front of your file was a petition for court-appointed attorney. The court has signed that. You will be assigned an attorney going forward. It will not be Mr. Kaplan. It will be someone else who relies on the information provided on your request for an attorney to be in contact and communication with you. Sir, you also have a right to be considered for pretrial release. The recommendation from Van Buren Township Department of Public Safety indicates that they do not oppose a personal bond for you in this matter. Any comment as to bond, Mr. Kaplan?
Yes, Your Honor. Per my discussion with my client, he doesn't have any criminal history. He has his GED. He does live in a different address than what I saw on the complaints. That address is in Taylor, Michigan, but he's still a local resident. I can provide the address to you if the court requires. He lives with his girlfriend and what he calls his stepchildren, because they're not married yet, ages 1, 9, and 5. He was gainfully employed prior to this incident, and looks forward to gaining employment again after. And so we believe a personal bond would be appropriate in this matter.
Thank you, Mr. Kaplan. In as much as Van Buren Township has indicated they don't oppose personal bond, the court will set your bond at $5,000 personal, Mr. Herring. You do not need to post any money, but what you must do is continue to appear as directed by the court until this matter is resolved in its entirety. Your next appearance date will be on Wednesday, April the 17th at 9:30 a.m. in person in courtroom number 2 with Chief Judge Brian Oakley. Again, this case number is 240018 FY. Next appearance date, April the 17th, 9:30 a.m. in courtroom number 2 with Judge Oakley. Is there anything else, Mr. Mr. Kaplan?
Different beard, but no, Your Honor, it's a pleasure. Thank you very much. I'm around if you guys need me the rest of the day.
Thank you. Mr. Herring, good luck to you. April 17th with Judge Oakley. Have a good day.
That's all.
Thank you, Your Honor.
Josh,
Yeah,
can you send me that address?
yeah, I'll just respond to your email on this, Jamie.
Awesome, thank you.
Mr. Grant, are you ready with Mr. Evans?
Yeah,
Yes.
I apologize.
No, his attorney is here with him.
Yes.
This is 230785 FY. This is State of Michigan versus Daquan Evans. May I have your appearances, please?
Okay, sorry, is there a prosecutor in the room or no? You're just asking me for my appearance. Neighborhood Defender Service of Detroit by Natalie Phelps, P83355, appearing on behalf of Mr. Evans, who is with us via Zoom. Mr. Evans, can you please state your name for the record?
Daquan Evans.
Thank you.
Thank you. No, Ms. Phelps, there's not a prosecutor. I was speaking to the probation officer.
Oh, okay.
Today is the day and time scheduled for the sentencing in this matter. There was an offense date of September 14, 2023 out of Van Buren Township. Mr. Evans was charged with receiving and concealing stolen property. He appeared before this court on February the 21st, 2024, entered a plea of guilty to the reduced count of receiving and concealing stolen property with a value of between $200 and $1,000 because of the allegations contained in the police report, or in the complaint in this matter, excuse me. The court asked the probation department to send written notice to the victim in this case to determine if they wanted to make a victim impact statement or submit request for restitution. That letter was in request for restitution. Information was sent to the victim in this case, and this court did receive documents from that person totaling approximately $2,900, but the documents were not clear as to the specific restitution sought or how it was tied directly to Mr. Evans. For that reason, the court is unable to enter an order of restitution this morning in this matter. That does not mean that it cannot happen in the future, but for right now, Mr. Evans, the court does not have sufficient or appropriate documentation to do that. This case was scheduled at 9 o'clock. It's now 9:25. There's no one who has appeared this morning presenting themselves as the victim in this matter, either on this court's Zoom or in this court's courtroom, which is open. That being the case, Ms. Phelps, was there something you want to say on behalf of your client?
No, Judge, we would just ask that you follow the agreement that we reached with the government in this case and sentence Mr. Evans to a short term of height of probation.
The agreement that was placed, thank you, ma'am. Mr. Evans, was there anything you want to say on your own behalf, sir?
No, ma'am.
Thank you. The only agreement that was placed on the record between Ms. Phelps and the assisting prosecuting attorney, Mr. Muhammad, is that this case would be subject to HIDA. For that reason, the court will place Mr. Evans on 6 months of probation with a HIDA status, will impose a fine of $500, cost of $200, their $75 mandatory crime victims fee, $50 mandatory state costs, $20 fund fee. Mr. Evans is to complete 12 hours of community service within the next 90 days. Sir, if you don't already have a nonprofit where you can get those hours done, reach out to this court's probation department. They have a file of agencies that would be happy to have your service, sir. You'll need to provide documentation of having completed those 12 hours. The total that you have due and owing to the court is $1,085. Make arrangements for a payment plan with the court's collection department. And just again, the issue of restitution remains outstanding. Should this court receive documentation that is clear and specific regarding the request for restitution, we will reach out to Ms. Phelps and have the matter scheduled to have you come back so that we may amend the sentence in this matter. If the victim elects not to proceed with their restitution request through the court, they are able to proceed against you civilly and individually. Was there anything else, Ms. Phelps?
Nothing, nope, not for me, Judge. And
thank you.
To start his probation, is there a number that he can call, or has he already been provided that?
Actually, Mr. Grant will reach out to him.
Okay.
He'll use the information that's already on file. So Mr. Evans, if your address has changed from Lexington or your phone number has changed from ending in 5317, then you would reach out to the court. But if your information is still valid and correct, Mr. Grant will reach out to you. If there's
Great,
nothing
thank-
else, you're free to go. Good luck to you.
Thank you, Judge.
You're
Thank you.
welcome.
Judge, is there anyone in the courtroom?
Is there anyone?
Yeah, with you.
Just Mr. Grant,
Okay, thanks.
not just Mr. Grant. That didn't come out right.
Step out if you want to. We have them, Miss Blevins, Miss Howe, and Tyrone Smith are all
If they're ready, I'm ready.
here. But they haven't been, Josh has been tied up in courtroom number 2, I think. So they haven't had the opportunity to speak to him.
Okay,
So as soon as I could get him in to talk to him, I will get him in front of you.
okay. I am just in the back then. When you're ready, just have somebody call back.
All right, sounds good. Thank you. ma'am.
Thanks. What are you doing in the interim? Have you already talked to them?
I only talked to Mr. Smith.
I'm just gonna give you your files then.
Okay.
Smith is, okay, these two are waiting to see, all three of these are waiting to see, yeah, right, that's what I told. Okay, so, okay. Yeah. Thanks for letting me know. Thanks, Steve. Okay, no problem.
You may be seated. It's too late in the morning for formalities. This is 230196 SD. It's the state of Michigan versus Don Blevins.
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of defendant probationer Don Blevins, who will be standing to my right, stating her name for the court.
Don Blevins.
Good morning, Ms. Blevins. Mr. Hadley. We were scheduled for review back on March the 4th, 2024 at 9:30 a.m. Ms. Blevins failed to appear. This court has had some concerns because she has continued to test positive for alcohol. And she failed to report at least twice in the last month to Mr. Grant. You've had the opportunity to speak to both Ms. Blevins and Mr. Grant this morning.
I have, Your Honor.
How are we proceeding?
After advising my client of the right to have a contested hearing, we will be pleading responsible to the probation violation. And we're prepared to make a brief allocution. I don't know if, well, Your Honor, we'll let this court decide where you want to go first.
Thank you. Your allocution, sir.
Thank you. Your Honor, I think best put, no one's here to make excuses, but other than just provide an explanation. Ms. Blevins has had a really difficult run. Between family loss, really some of the tragedy that has been involved with the family lately. She's really looking, I guess you'd say, move forward from this incident, and would ask that the court show understanding that he owns responsibility for mistakes, knows that there's an issue here, but will still get this court her reassurances that you won't see her again for any new criminal conduct or any other activity. We would ask that you discharge this probationer at this time as an unsuccessfully completed probation.
Mr. Grant.
I agree, Your Honor. Ms. Blevins has had a difficult time. I know she's had a lot going on. She has reached out to me, and I believe she's doing the best that she can, but unfortunately, she has not met the need of the court. So I agree that we should discharge her unsuccessful.
Thank you. Ms. Blevins, is there anything you want to say on your own behalf, ma'am?
I'm honestly trying my hardest. I have been through a lot. Taking one day at a time and moving forward.
Understood. Ma'am, the court accepts your plea of responsible to the probation violation and will adopt the recommendation of the request of Mr. Hadley and the concurrence from Mr. Grant that you be discharged as unsuccessful from probation. As Mr. Grant indicated, you've talked to him and he's talked to me regarding issues that you're having with both your husband and your family. And it's just a lot of balls in the air and the court doesn't want to add to that. The only thing you have remaining with this court is a small balance, it's $216, we'll turn the matter over to collections. You just make arrangements with them to pay what you have remaining, but we will close out this probation at this point.
Thank you.
You're welcome. Is there anything else, Mr. Hadley?
No, Your Honor, thank you for hearing us out today.
Understood. Ms. Blevins, you have a wonderful afternoon. Good luck to you, okay?
Thank you.
Thank you. Two three zero five eight seven OD. This is City of Romulus versus Tyrone Smith.
Good morning, Your Honor. Attorney Josh Hadley, here on behalf of defendant probation, Mr. Tyrone Smith, who will be standing to my right and stating his name for the record. Good morning, Tyrone Smith.
Good morning, Mr. Smith. Today is a day and time scheduled for the violation hearing. The court has received a report from Mr. Grant that indicates that you've provided documentation showing your completion of the substance abuse treatment as well as your community service. You took care of the warrants you had outstanding in another jurisdiction, and that you have maintained the payment plan in this matter. That's a big improvement from what originally brought you onto this court's radar regarding being non-compliant with treatment testing and community service. Mr. Hadley.
Thank you, Your Honor. After advising my client of the allegation regarding the positive marijuana test and failure to present the medical marijuana card, we will plead responsible with a technical violation. But as this court has indicated, I think it was indicated, that documentation is valid and has been provided to the probation department. I believe probation's recommendation would be to continue with probation. We would ask the court to recommend or adopt the recommendation. If I'm correct and not putting words in Mr. Grant's mouth.
That is correct. The only thing I'm questioning you, Your Honor, is are we accepting the medical marijuana card or for moving forward or
for testing purposes?
I believe that we are for testing purposes. It's, this court can't undo the state's legalization of marijuana, and you have now presented to Mr. Grant what I believe is acceptable proof of your use of marijuana. So the court has accepted that card, and going forward, so long as Mr. Smith, I don't know, what do you do with that, Mr. Grant? When you test, are you just testing for alcohol now and disregarding marijuana, or are you not?
It'll still show a positive for the marijuana, but we are, if it's approved by the court and he presented the medical marijuana card, it's just, I guess, overlooked.
Your Honor, in my experience with other jurisdictions, we're trying to make new case law by prohibiting this in spite of the Court of Appeals ruling. I'm seeing testing still being done because some places are wanting to monitor cannabinoids level, THC level to see if it's consistent with medical use. I don't know. It seems like that's the standard if they still test for it, even if it's permissible.
You make law that makes it hard to apply the law, but at any point, in any case, Mr. Smith, the court has accepted the plea of responsible to the technical violation. Will continue you on with probation. Allow the use of the medical marijuana as indicated with the documentation that you submitted to Mr. Grant. There's a small balance that remains due and owing in this case of $175. It appears that you've done the bulk of what was requested of you by this court. So continue to test as directed by Mr. Grant. Other than that, was there anything else, Mr. Hadley?
No, Your Honor.
Oh, I'm sorry. Is there any way I can get released with probation early if I take care of everything as far as balance and everything?
There are other conditions.
It's just that I work 7 days a week, 11 hours a day until we get off emergency status. That's my schedule.
Since date was November of 23, discharge date would have been August of 2024. We're 4 months into a 9-month probation.
Yeah. Usually it's that half, so we're right. I think we're just about right there. You said it was November. I was trying.
November 13th.
Okay. Yeah, I will get.
Mr. Smith, let's do this. submit an email request to Mr. Grant for early discharge. I think we're at that. I think we are where we're supposed to be. But I just want to make sure and have a paper trail that you've made your formal request to be discharged early from probation. The money, that's $175, will not be what would cause the court to deny your request. I just want to be sure that you've done everything that Mr. Grant needed you to do and that there's nothing outstanding. He'll want an opportunity to run your most recent, look at your most recent criminal history and driving record, which I think he did before he submitted his most recent memo to the court, but submit that formal request by email. He'll send it upstairs to me. You won't have to come back.
Thank you.
Okay? Anything else?
Nope, we're all set, Your Honor.
Thank you. Mr. Smith, good luck to you. Have a good afternoon.
Yep.
I just want to be sure that the documents you have are everything that you needed.
No, you're right.
Okay.
I wasn't prepared to.
I know, it's,
Yeah, I didn't know he was gonna ask that one.
23BL00671B. This is Belleville versus Olivia Howe.
Good morning, Your Honor. Attorney Josh Hadley, appearing on behalf of probationer defendant Miss Olivia Howe, who's coming to the stand today. Please state your name.
Good morning, Ms. Howe. How are you?
Good, how are you?
I am super. You look a lot better than the last time I saw you.
Thank you.
How
Doing
are-
better.
How are things?
Getting way better.
Good.
Tell her.
Oh.
Oh, you know, Your Honor, I'm sorry, we can get the formalities out of the way.
Thank you.
Sorry.
Ms. Howe, the last time you were here, you had continued to test positive contrary to your orders for probation. Based on that, the court ordered you into incarceration for a period of 15 days, having found that you violated the terms of your probation. You have now completed that time, and the court did receive from the probation department, Mr. Grant, an indication that you have provided him sufficient documentation to confirm your intake at First Step. There is a concern that you have continued to test positive for alcohol and that you missed the test on March the 13th, and you have a test that's pending from April the 2nd, 2024. There are no new offenses on your criminal history or your driving record. Mr. Hadley, what was it that you wanted to say, sir?
Your Honor, as to the technical violations with the missed test, completely responsible. As to the positive testing, Ms. Howe still asserts that, again, there's something that she's been working with her therapist doctor to try to figure out what she believes is causing this. But for our purposes today, we'd be pleading responsible for the technical violation of this test. I would note that she did reach out to counsel upon missing it because she was working through rides, costs.
I wouldn't.
And she went, yeah, it was different, the next, yeah, oh, and they couldn't produce a full sample on one of the tests. Your Honor, I'm also holding some paperwork in front of me that says that Ms. Howe has taken forward steps. As you mentioned, being the therapist, it's also that community service has been initiated. And I think of greater importance, she's related to Mr. Grant, myself. Her mother is willing and ready to come back to Michigan, help her pack up, move, and she has secured the services of a therapist, weekly services every Wednesday in North Carolina. She'd like to move back, move in with her family and work towards really a full comprehensive rehabilitation of just not substance abuse, but mental health. Has gone through a pretty traumatic period of time while she's been here in Michigan. Your Honor, we would ask within your discretion, we'll rely on what the probation department's recommendation is, but we do think that she's shown tremendous effort since, as you said, the last time that she was here.
Thank you. The court accepts the plea of responsible to the technical violation for the missed test. Mr. Grant, what is your recommendation at this point?
I would recommend that we discharge Ms. Holland successfully.
Mr. Hadley, was there anything else?
No, Your Honor, we would absolutely ask the court adopt that, and again, would wish her and her, endeavors to get back with family, all the best.
Ms. Howe, was there anything you want to say on your own behalf?
I'm talking to my mom again. She's great. My dad's coming back around. I see her tomorrow and I'm gonna get better and get this back, so.
Ms. Howe, the court will adopt the recommendation of Anthony Grant from the court's probation department and discharge you as unsuccessful probation. As I indicated originally, you look a lot better than the last time I saw you. Mr. Grant and I have had multiple conversations about you over these last 2 months and believe that you're best served by being able to be with family and being away from the environment that has led you astray at certain points. But that being the case, I wish you the absolute best with your parents, and I hope that you continue to get the support you need. If there's nothing else, you have a wonderful afternoon, okay?
Yeah.
Thank you. Remaining on this court's docket are they were due at 9:30. It's 10:04. If you want to go, you can, but I don't. This is 2307650D. This is Van Buren Township versus Ohagi Fulton. This case was scheduled at 9:30 a.m. for a probation violation hearing. The last time that Mr. Fulton was here, he was directed to report to the probation department for testing before the end of the business day, and was advised at that time that a positive test may lead to his being incarcerated. This matter was scheduled at 9:30. It's now 10:04 by the court's clock. The report received from Mr. Grant that is dated April 8, 2024, indicates to this court that Mr. Fulton has failed to provide documentation for either substance abuse treatment or community service. He failed to report for drug or alcohol testing on March the 26th, and failed to report for his monthly meeting on April the 3rd, 2024. That Mr. Fulton has multiple warrants for traffic offenses, including 3 cases in this court, the 34th District Court. Mr. Grant, was there anything else you want to say on this matter?
I only ask that it goes into warrant status, Your Honor.
Absolutely. This case being scheduled at 9:30, it now being 10:05 by the court's clock.
Evans, Fulton, and Gray are the ones that didn't show.
Correct.
Okay.
Thank you. Mr. Fulton having failed to appear, bench warrant shall issue in this matter 5,000, 10%. 1706990 OM. This is Davion Gray. This case was scheduled for a violation hearing. Mr. Gray was arraigned by this court back on March the 26th, 2024, and was allowed personal bond, directed to appear here this morning at 9:30 a.m. for a violation hearing. It is now 10:06 by this court's clock. Defendant having failed to appear, bench warrant shall issue 5,000, 10%. Two three zero seven six four. This is Van Buren Township versus Amaria Massey. This case was scheduled at 9:30 for a violation hearing. The report indicates that Ms. Massey has failed to appear for testing, although she has completed her substance abuse and community service. She's made payments as directed, but she has failed to appear twice for testing. Based on her failure to appear this morning, bench warrant shall issue 5,000, 10%. Mr. Grant, was there anything else this morning?
No, Your Honor.
That concludes this court's probation docket. We remain on the arraignment schedule, so we'll wait further direction from downstairs. If there's nothing else, Mr. Hadley, you have a wonderful afternoon, sir.
As well, Your Honor.
Thank you. Oh, not you, Mackenzie.
We have the medical marijuana card development. So the Secretary of State's where my next like arena of fighting with them is. So David Rudoy, pretty good, you know, David, yeah, he got a published opinion saying Secretary of State can't deny your reinstatement of your license based on that. And the Secretary of State's basically gonna hold my beer. And they're now sending people out to get paperwork done. So like you say you have like crashing in the back of somebody 3 times in a row, and like we need a doctor to figure out why it is you keep crashing, go get this form done. They're sending marijuana patients out to go get that same thing done now. And yeah, making the substance abuse evaluators basically attest that this person doesn't have a problem smoking marijuana. Like how somebody, how are you gonna ask it, right? Like have a substance abuse evaluator say that they're using it under a doctor's guidance, but yet they're not addicted. They're like, well, you would do that with Vicodin. I'm like, do we? I've had plenty of people with the Secretary of State who are on pharmaceuticals, and never once have I seen them send somebody to go see their physician to get a whole bunch of extra paperwork that says, yeah, he's not addicted to the back meds that I put him on. Yeah.
You saw this coming.
Sure.
And it was just a matter of time. And now that we're here, it's kind of like.
It's gonna be a lot of appellate work, because there's so many nuances.
You all
to
have fun
this.
with that.
We will, but it's just like, you're right, they kind of just threw it in there and we're like, well, what about this? Well, what about this? There's a lot of like caveats to say that somebody could smoke dope while they're on.
Well, we don't make law down here. We just enforce it. Would you drop those off for me, please? Thank you. And that's why I stay out of it. If you present a card or doctor's note to probation department, what are we supposed to do?
It
You
was
know?
certainly a point of questioning that a 3-letter group out of Lansing who looks into allegations against me, judges in Oakland County, had for me about, hey, is it true that this guy is telling people they don't say on the record why they have a card? They won't let them do it. And I was like, I haven't heard him do that. And they're like, yeah, you know what HIPAA is? I know what HIPAA is. So I guess in open court, they're like saying, hey, tell me why you need the ganja, and maybe I'll let you.
It's-
Like, I have cancer.
It's just
They're
like any,
oh, no.
it's just like any other piece of paper that you submit to probation, unless Mr. Grant or Ms. Rapp send it up to me with a note that we question the validity of it. I can't look behind it. I'm not gonna ask the doctor or the treater provider to send over their medical
Yeah, you get a
reports.
doctor's note, look like a ransom note, like somebody cut it out of the newspaper. You're like, you know.
I mean, I've seen some suspect stuff that's clearly cut and paste over the years, but nothing from the probation department that makes me question it. And until we get something like that, or until there's further guidance, my hands are kind of tied. I have no desire to be on someone's radar for not following the state of the law as it is. It's not for me to agree or disagree. It's for me to read the most current opinions, the most current guidance, the most current FAQs, and move from there.
And let us nerds argue about the nuances of like what you can and can't do in the appeals.
Well, which I get the Supreme Court argument schedule and I go through it. I'm like,
Knew this
this
was
is something I
coming.
want to listen to.
Good to see you.
Good to see you.
The first medical marijuana card somebody presented when I was here and in probation looked like she did it on her own computer, because the picture was so big and it actually covered up the title of the medical marijuana. So I called them and they're like, no, it's an error that happens about 1 in every 1,000 cards. We don't know how it slipped through. We'll put her name down and send her a new card. I'm like, this is like she made it in her basement. It's kind of like, yeah, it's bad.
If you tell me that your treater says that you need to use marijuana, but you've done everything else that I've asked you to do, and you continue to hold down your employment, hey, it's not for me to look into.
I don't know why Mr. Smith waited 4 months to tell me he didn't have it.
It used to be until the opinion that came out like 2 years ago or whatever, the previous published opinion on this, what the guy had done is a probationer gets arrested in January, goes and gets a medical marijuana card in February for your back injury that happened in the July of the following year. And they called shenanigans on that. But this new case pretty well flipped that over. Now
Right.
it's like you can basically race to the doctor to say, "Oh, right before you get tossed on probation."
Then stop anywhere you want in Monroe and get it filled.
Never dull moment.
No, so a buddy of mine that I went to, he's from West Virginia, but we were up there some state like at the same time.
Yeah.
And he's a PhD in geology. I'm very told this thing runs like a map. We're not using mass spectrometer, working on rocks from the moon and stuff.
Right.
He and a buddy of his who's a lawyer opened up one of the marijuana lab testing facilities out in Arbor.
Okay.
Sci Labs, like PSI. They recently shuttered and went public to the feds and the state that there's no oversight of their industry. So what happened, he's like a legitimate scientist. They were losing a crazy attrition of customers. And the customers, the growers, were contacting him and saying, I took this to ABC testing facility up in Penn County, and they said it's 24% THC. Yours came back the same stuff and said it's 19, because it is. Well, if we're not getting better numbers from you guys, we're gonna have to go study something in Penn.
So they're shopping for what they want.
For the lab, my buddy reached out to their testing facilities, trying to do this like scientists, and said, can I see peer review, where is it that we're making a mistake? I want to make sure that my lab.
Right. Because isn't Ohio just passed, right? But their standards or their THC levels are lower than our Michigan. Yeah. So that's why we were talking, because there's a shit ton of them down here in Monroe, right across the border, and it's all.
I was just, buddy of mine was in, he came in from West Virginia, so he on his drive out, like, hey, I'm sure everyone's giving you the careful driving into Ohio or Michigan, but like, especially right now, they got like outlet malls full of dispensaries, just like the state line. once everything's checked off. Yeah, this was scheduled for your payment today, last payment, food service done.
Yeah, I'll move everything that's super rough stuff.
We want you, yeah, we want you to get that back. Did you get one of those scam letters that said? Yeah, basically, they're scams. I couldn't remember if you were talking about it. There's been like a lot of those.
Yeah, it sounded like that was actually.
No. Have you selection those, Mr. Grant?
Yeah,
You see some of those?
somebody brought one in to me, yeah.
There's somewhere on in small print that will say this.
Yeah.
You gotta look for it. When you read it, it looks like an order telling you the right thing.
Yeah, that's why I was looking for. Reporter and be stuff. Can't be managed.
No, it's hovering right on the line. It's not over. It's right at it. Who are you?
We're just waiting for Mary.
Okay.
That's our call right here.
I didn't even see it over there.
I'll own that, because Jennifer asked me to cover if she came in.
Oh, yes, I don't know.
I just didn't think to go look on the sign-in sheet, so.
And when she came in, I looked at the sheet and it said Jeff was her attorney, so I told her, put your name down there, put Bowditch next to it. And she did that.
Which normally that would be exactly what we do. They've gone, like I said, a couple times for a little bit, they were removing our names as the appointed attorney for show cause, that didn't happen. And then another kind of.
Yeah, because it looked like I was, when you put his name down.
Well, he's working in the courtroom there, which is doing.
Is
did you put the little one up there?
I did, so she's set, yeah.
Okay. Mine was not. Well,
Yeah, I was surprised, I even went downstairs after, and your file was one of the. I'll check to make sure. Oh, that's probably one here. And I'm like, I can't hear those.
That's a good thing you're probation. I'm surprised you didn't number.
I know.
I knew it.
Yeah, the other ones I predicted to not be here, but you, I was like.
Did you get any paperwork from the Secretary of State after the guilty plea? They mail you anything? Did you do an OWVI for yours or an OWI?
Yeah, they had told me that,
I don't have the ROA in there.
they had gave me a restricted license at first.
Yeah.
And it was just like a little sheet, and then like a week later on, I went to Secretary of State to get, an ID, and then like a week later, they had.
Okay. I'm just learning to follow up with people a little more on that because it seems to be, I got people who are at least reporting back to me that having different timeframes when things are getting mailed to them by the Secretary of State. It used to be pretty much like, you could predict if you say guilty on Monday, letter from the Secretary of State gets generated on Wednesday, gets there by Friday, you know, and it doesn't seem to be following the same kind of pattern.
What was the letter say?
That you have a restricted license from this, you.
Oh, yeah, that was good.
Yeah, so Secretary of State has been notified that in the 34th district, you had a plea of guilty to blah, blah, blah. From boot to boot, you're restricted, or suspended. Because for the temporary suspension one, I've had a few people, I think there's $125 reinstatement fee, so a few people who misread the paper from the Secretary of State hit me in of like the suspension period, which isn't even, not restricted, an actual suspension. All right, cool, I'm good to go, but they don't actually go back into the Secretary of State. Fast forward, getting pulled over, driving while suspended and bought. They were good to go. So
State wants their piece of it.
I think they got hacked like a month ago. I still haven't untangled it, but I got what looked to be a notification through the MI third party. Like if you're trying to log into your own Secretary of State like online account, like just as a mission driver, there's something that looks like that, but for third parties and attorneys to log in and file stuff on behalf of. Whatever I got was an email from, it looked like the state, but like it was like one letter spelled differently. It's like, your hearings have all been scheduled. I'm like, I didn't ask for any hearings. Who is this? Like, what is this? There's no one at the Secretary to call.
Right.
So like I just get like a 517 number, call it, I'm like, oh, this is the same thing.
It's like trying to get something handled at the 36th District Court and who to call down there.
I'm just
I need to log in to Secretary of State because they sent me my my voters MC. They sent it to me in the winter and I did one of these things where I'm gonna put this right here so I remember where I put it. So
they have expanded like what you can get done. There's a lot of stuff that really saves them.
well, I paid for it. They sent me the sticker. Now I just can't remember where I put the darn sticker. I'm sure there'll be some sort of fine, but it won't be, or a fee, but it won't be a full, yeah.
Like you're not asking for another one, you're just saying I lost.
And I know as soon as I do that, I'll find the one that I put somewhere.
It is. And then compared to the, if you don't do it.
Right.
That's a lot. That's crazy. And better hope everything else in your day is up to speed because that could be enough, or it is enough to get stopped. Under Michigan law now, just if officers just behind you, so just run a place now to make sure that everything got valid insurance, tabs. They thought about that for a minute, didn't they? Whether that was probable cause, like just they were landing with it. Yeah. That's you don't need a warrant to just run a license plate to see if the driver's got valid insurance and tabs. I mean, the tab you can see on the sticker. I don't know. There is, and I think we've made some progress, but there's just so many people in Michigan who are driving without licenses that kind of need to come up with it. Lots of it falls on people who need to get on top of their stuff and do better, but a lot of it also, some people, is just sort of a circular like pattern. I have to drive for work, like, and if I don't work, I won't have enough money, and you start kind of getting into it. Like, depending on where you live, a bus, or mass transit is not a super doable option for a lot of people in southeast Michigan. So it doesn't excuse driving without a license, but when somebody's like, I have to drive to get to work, kind of, like I see that too.
I would tell them because I'd pull them over and I'd tell them, I understand that. Why are you doing 60 and a 45? You know you're suspended. You know.
I could just see you like initiate and stop and like, yeah, I get that. Here's the thing.
I sympathize with you,
Here's
but
here's a ticket and a little bit of helpful advice, which is.
That was always like the drunk driver who had the passenger had a valid license and hadn't had a drink. all night. Why are you doing that?
Yeah,
That was usually met when the wife's driving home. And then like,
that's right, I'm fine. Okay. And I was just talking to the prosecutor out there, and I'm not necessarily like saying this is what we should do, but we're talking about putting things in cars that disable your ability to talk on your cell phone, or, use it, or it has to be wireless, airbags with turn signals. We got a lot of things that have to be on the car for safety. We know that there's interlock devices that work that will say if you're at 0.08 or above, the car will start. We just still really haven't taken that next jump to say, we can probably eradicate drunk driving to like 95%. There'll always be so much feedback around.
Still waiting. You're getting up.
You have to blow into it. Yep, and it's signed to, it's set to like legal blood alcohol kinds of level. The ones that they use here are set really low because you can't make alcohol. And I think they set it like 0.002 or something. So people are like, I just have a little bit of mouthwash. You get a little bit more than a little because you could still, it'll still start. It'll show that you had a very, very low amount, but it'll still start. But the science is simply something that's simple as reprogramming that same device. Say, okay, if everyone says 0.08 is the limit, we're going to set the breathalyzer at 0.075, and then say you took your last drink, get in the car, you're driving home, it's going to notify you your blood alcohol content are set up. You're now. Because that's only hiccup with that. Because blood alcohol content out of an hour and 15 minutes after your drink is when it hits its peak, its highest level in your system. So when he was an officer, I tell you, some people like the roadside stop. If you just like freshly coming out of the bar, you may do a roadside test that may show that you're like somewhere in here, but by the time they would get them back to the book, that alcohol that they shoot, those 4 shots that they just hammered back right before they jump in the car finally hit, and they'll come back with a. No 0.08. 0.8. Yeah.
I've never seen them that high.
The record breaker I had was the guy up in San Juan County. He went in the hospital for 4 days.
No, it was, well, that's Ken. Looking for you everywhere except in your hangout spot. This is a recall of 230-764 OD. This is Van Buren Township versus Massey.
Good morning.
Good morning. Your appearances.
Good morning, Your Honor. Attorney Josh Hadley, bring on behalf of probationer, excuse me, Ms. Massey. Please state your name for the court.
I'm Mariana Massey.
Thank you, Ms. Massey. Today is the day and time scheduled for a violation hearing. We had called this case previously, ma'am, at 10:07 a.m., showing you as a failure to appear. The court putting the file for issuing of a bench warrant. The court was then advised that you were actually here, but you were waiting to be seen in the wrong courtroom. That being the case, warrant not having been entered. Let's get back to the original reason why we were here this morning, the violation, having found that although you have completed your substance abuse assessment and community service and provided Mr. Grant with adequate documentation, that you failed to appear for testing. And this is the second failure to appear. You've had the chance to speak to Mr. Hadley. Mr. Hadley, how are we proceeding?
Thank you, Your Honor. After advising my client of her ability to help contest hearing and her rights as a probationer, we will plead responsible. It's my client's decision to plead responsible for the technical violation of missing a test. I believe so. It's March 12th. Explanation briefly was it was illness that you said, right? That you missed that day because of being sick. would point out that all subsequent and prior tests all came back negative.
Thank you. The court will accept the plea of responsible to the technical violation of the terms of probation. Your recommendation, Mr. Grant.
Just to continue with me on probation.
Any objection, Mr. Hadley?
No, Your Honor.
Ms. Massey, we will continue with your probation. Going forward, if there is something that comes up that prohibits you from either appearing on time, testing on time, or reporting on time, please reach out to Mr. Grant as soon as possible so that the court remains aware of your situation and does not take it as a violation of probation. It looks like we are just 3 months into a 9-month probation, so if there's nothing else, ma'am, good luck to you. Have a good afternoon.
Thank you as well.
Thank you.
Thank you, Your Honor.
It being now 10:59 by the court's clock, the court not having received any information from from the court administrator's office that there's another arraignment pending, we will stand in recess. Oh, no, we'll stand adjourned.
We have